Good afternoon. Excuse me. The Hearing Board of the South Coast Air Quality Management District is in session. Today is October 24th, 2017. The time is approximately 1:05 p.m. Today on the agenda we have one matter to determine and discuss, and that is South Coast Air Quality Management District versus Rainbow Transfer Recycling, Inc., case number 4394-2. It is a continued hearing for a modification of the stipulated order for abatement. And who is representing the executive officer today?
Karen Manwaring on behalf of the executive officer.
Thank you. And who is representing Rainbow Transfer?
Good afternoon, Madam Chair and members of the hearing board. Tom Bruin for Respondent Rainbow.
Thank you. Before we begin, we have a couple of preliminary, we received a number of additional exhibits from the respondent Rainbow, and so let's mark those at this time. The first one was an email from Charles Tupac sent Friday, April 28th, 2017 at 11:38 a.m., and let's mark that as ZZ for the letters ZZ for respondent. The second document is an email from Karen Manwaring dated Friday, July 21st, 2017 at 12:14 p.m., and we will mark that as AAA for respondent. The third document is a multi-page document on South Coast Air Quality Management District letterhead addressed to Mr. Craig Campbell dated June 20th, 2017, and the subject is various permit units at Rainbow Environmental Services, and we will mark that as BBB, triple B for respondent. And we have, the last one is entitled Attachment Number 1, Suggested Findings and Conditions of Approval, and we will mark that as triple C, CCC for respondent. And when we last left off, Mr. Bruin, I believe you had an additional witness.
Yes, I actually had some redirect from Mr. Thompson.
Correct.
And then I have one additional witness. So hopefully it won't take too much time.
Thank you. I'm going to ask the two witnesses to please rise to be sworn in, and if there is any member of the public who also wishes to testify, if you can rise at this time to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Before we begin, Mr. Bruin, Ms. Manwaring, is there any preliminary matters you would like to introduce?
No, thank you for asking.
Thank you. Mr. Bruin, you may proceed.
Thank you. Mr. Thompson, at the last session before the hearing board, you had described how extreme rain during the prior winter interfered with the foundation work for the transfer station foundations, which caused a loss of 38 working days. You recall that testimony? Yes. And you also indicated that the building permits from the city of Huntington Beach for all three buildings was delayed about 7 months?
That's correct.
And that's 7 months compared with the original schedule you'd presented to this hearing board when the stipulated abatement order was adopted?
Yes.
And you also described to the hearing board how the city had required a stormwater infiltration system to be installed at Rainbow as part of the proposed improvements, which required the excavation of the employee parking lot in the summer of 2017. You recall that testimony?
Yes.
I believe you also testified that the hearing board had requested that Rainbow make the construction of the transfer station the first priority from among the three buildings being the transfer station, the material recovery facility building, and the secondary recycling building.
That's correct.
So transfer station came
Transfer
first.
station first.
And I want to clarify, I think there was some testimony on this, but just so the record is clear, in order to build the transfer station, which would expand the transfer station footprint out into the area where Rainbow previously did green waste processing, during the transfer station construction, it was necessary to move the green waste processing operation to the area where the secondary recycling building was to be built.
That's correct.
And you couldn't start on the secondary recycling building work until you moved the green waste operation back into the transfer station.
That's correct.
Another factor in terms of starting work in that area was that that area was used for employee parking while the excavation work was going on in the employee parking lot.
Yep, yes.
And were there other things going on in that area other than the green waste operation and employee parking?
Well, there's a continued C&D operation, construction demolition material operation, and there was a stockpile for some soils there, as well as some bin storage and just general maneuvering area for vehicles around the site.
And you talked about a soil stockpile. Where did that soil come from?
Came from the infiltration pit.
So when you did the excavation, you had to put the soil somewhere?
Yes,
Okay, and that was in the area where the secondary recycling building footprint would be?
yes.
Okay. Based on your 42 years of experience in the construction industry, at this operating facility, could you have started work on the secondary recycling building any sooner than you did?
Not with all the variables that we had to make sure were in place and safe.
Now, going to our request for an extension today, you've testified that the building permit for all 3 buildings was delayed 7 months. Is it true that despite that, the transfer station is now done?
Yes,
The air handling units are up and running?
yes.
The green waste operation has been moved into the transfer
Yes,
station?
yes, it has.
And with respect to the material recoveries facility, that's expected to be completed when?
Middle of November.
So despite the 7-month delay, you're going to meet the December 1 completion date for both the transfer station and the material recovery facility building.
That's correct.
And despite that 7-month delay, we're here today only asking for an extension for one of the 3 buildings for a 6-month period.
Yes,
There was some testimony about project costs, and I just wanted to clarify one thing. You said that the project costs for the proposed improvements at Rainbow that are the subject of this abatement order have risen from the original estimate of $11 million to $20 million?
that's correct.
Did that $20 million figure include the $4 million that Rainbow has donated to the Oakview School for the construction of a new gym?
No, does not.
The $4 million's on top of the $20 million.
Yes,
Now, there were some questions about the timing of our petition for an extension. So I'd like to ask you some questions about when we knew how much of an extension we would need to ask this hearing board for, and what buildings we would need to ask for an extension to complete. Madam Chair, members of the hearing board, I don't want to confuse the board. We're not quarreling with the timing it took the Air District to issue our permits. They were not a critical path item for the construction here. But I want to ask some questions about when we knew the Air District permits would be finalized and how that would affect our ability to know how much of an extension to ask for and for what building. So that's the purpose of the following questions. Now, Mr. Thompson, during the process of working with the Air District on the air permits for the Rainbow facility, were you advised by the Air District that a 30-day public notice period would be required?
yes,
So that after the permits had been finalized by staff, copies of the permits would be sent out to members of the public, and we'll get into the details of that in a moment, for members of the public to comment on those permits for 30 days.
that's correct.
And were you told that after that 30-day period, if comments were received, the Air District would need to take additional time to respond to those comments?
Yes,
Were you also told that the Air District might actually process a change in some of the permits, depending on what kind of comments they might get from the public?
yes,
So the public notice period was not just a formality, there was a chance that the permits could be further delayed or revised,
that's correct.
which would take additional time.
Yes,
So I'd like to show you Exhibit ZZ, which has already been described by the chair, and it's a email from Charles Tupac to Craig Campbell dated April 28th, 2017. And let me just ask you if you've seen this email before.
yes, I have.
And just for the record, I want to read, I just want to read a couple of the key sentences here. It's, "Hi, Craig. Sorry I couldn't reply sooner. I participated on an interview panel this morning. We are very close to completing the evaluations and proceeding to the public notice step. Regards, Charlie. And then I'd like to show you Exhibit AAA, which is a copy of a email from Ms. Manwaring to myself dated July 21, 2017. And did you receive a copy of that email from me on or about that date?
Yes, I did.
And would it be fair to say the substance of that email was to advise Rainbow not to begin work on the yellow boxes, the air filtration units, until we had the air district permits in hand?
Yes, that's correct.
So let's talk about the importance of working on the yellow boxes. If you couldn't complete the yellow boxes, which were the air handling units, the air filtration units, you couldn't start operations inside the transfer station and bring the green waste inside. Is that correct?
That's correct.
Which meant you couldn't get the green waste off of the area where the secondary recycling building was.
That's correct.
So the air permit was a pacing item for completion of the transfer station.
Yes,
And getting the air permits for the material recovery facility was also a pacing item for completion of the material recovery facility.
yes,
Let me show you Exhibit BBB, which is a series of documents. The cover letter is a letter from an Andrew Lee to Mr. Craig Campbell dated June 20, 2017, which, just for the record, encloses the public notices in English and Spanish that were received by Rainbow. And then I've also attached to this exhibit, so it's really kind of two documents, but I stapled them as one, permits to construct, and there are 24 different permits to kill less trees. I copied 2 just to give you an exemplar of the permits, and so you could see that the permits were issued on August 17th, 2017. So, Mr. Thompson, did you see a copy of this public notice letter from the Air District when it came in on or about June 20th?
I did.
And so this started the 30-day period in which people could comment on these permits?
Yes,
And again, until the public notice period passed and you knew whether there were any comments or any further delays or changes in the permits, you wouldn't know exactly when you'd get your authority to construct.
that's correct.
And per the email from Ms. Manwaring, until you had the authority to construct issued, you couldn't complete the yellow boxes for the transfer station or the MRF, correct?
That's correct.
So let's assume hypothetically, if the air permits had been delayed, say another 3 weeks or 4 weeks, would you have been able to complete the material recovery facility building, for example, before the December 1 completion date?
No,
So until we had the air permits in hand, we didn't know how much of an extension we would need to ask this board for, or what buildings would be covered by that extension request.
that's correct.
Is that a fair statement? All right. And for the record, I'd like to note that we sent our petition to the clerk on September 1, 2017. With that, I have no more questions on redirect for Mr. Thompson. I would like to move exhibits ZZ, AAA, and BBB into evidence.
Ms. Manwaring, any objections?
No objections to the request and no questions for Mr. Thompson.
Thank you for taking care of both of those in one swoop. All those exhibits are in evidence. Board members, any questions on this additional testimony by Mr. Thompson? Anyone? Yes. Senator?
There were public comments based on the 30-day notice, and you testified that there may have been changes based on the information received at the public comment.
Yes, sir.
What were those changes made?
There were no public comments.
Senator, maybe I should clear this up with Mr. Thompson. In fact, as it turned out, there were no public comments, and when the public comment period expired, the permits were immediately issued by the Air District?
Yes, that's correct.
Thank you.
I thought you said there were some comments made subsequent to the public comments.
No, I'm sorry if I misstated something, but there was no, we had to wait to see if there were going to be any public comments made during that period of time.
So since there were no public comments, there were no changes made,
That's correct.
so you could go forward. So the only thing that held you up was the 30-day notice required.
Yes.
Okay. You are aware that as November, I think it's November 13, end of November 13, there were 13 NOVs issued against your operation.
What's the time frame for that question, Senator?
At the end of 2013, November 2013, there were even more. The district has issued 13 notices of violations since the end of 2013.
Mr. Thompson, you can answer if you know.
Were you aware of that?
I'm not specifically aware of those NOVs. We weren't involved with the project at that point.
It's listed in your document, Mr. These numbers.
Senator, I don't think there's a dispute that before the abatement order was issued, Rainbow had received NOVs from the Air District because of odor complaints.
The abatement order was issued 2015.
Yes, sir.
And the date on that was, I believe, (2015), that, I don't know the exact date. It was issued November 2015. And this is, more problems continue to exist beyond that date. Now, the other thing that you talked about, that was discussed at the last hearing, was that there was 15 change orders, 15 changes. The district engineer testified that there were 15 different changes.
Senator, with respect, I believe that mischaracterizes Ms. Shabata's testimony. I think she said there were 15 submittals, and there were 24 different permits. And I think she said the number of submittals was not unusual for this complex a project.
15 design changes. She had to change her design 15 times. And it was attributed to the fact that you still were working up in Huntington Beach, trying to make changes there, and it necessitated changes that the district had to make, and that was not all, that was none of the district's fault.
I just wonder if there's a question. And I do have in my notes, Ms. Shabata's testimony, 12 to 15 revised drawings was, 12 to 15 revised drawings, which was my notes, but is there a question for Mr. Thompson?
Well, I'm just saying that Mr. Thompson is suggesting that the delays were was beyond his control. That's what I think he's suggesting. I'm saying with those number of changes, are you think that you should have been more communicating with Huntington Beach to make sure that you didn't have those kind of changes?
Senator, if I could just remind Mr. Bruin, in his opening to Mr. Thompson's additional testimony, he reminded the board that there were two separate permit reviews, one through the district and one through the city of Huntington Beach. The request that is before us today and was at the last hearing is for an extension of the date for completing the secondary recycling facility based upon, in part, a delay in the permitting from the city of Huntington Beach. But the testimony we just heard was with regard to the district permitting, and that they are separate.
I understand that.
And that is not the basis on which the request is.
I understand that very well. But they're also requesting that they be forgiven of the request from the district that they pay $250,000 because beyond this.
The request of us is not about the 250,000, but to make a finding of force majeure under,
Which would relieve them of paying the $250,000 the district is requesting.
right, but regardless of why, we do have the ability to or not to make that decision. But yes, we would have to make that finding.
That's the whole point I'm trying to, I think the point was making that it was beyond his control, therefore, they should not have to pay the $250,000. He's presenting two arguments at the same time.
Again, the force majeure finding that is being requested of us also is related to the city of Huntington Beach permitting, not the district's permitting,
I
just to
understand.
be clear.
All right, go ahead.
May I call my next witness?
Well, let me just see if any other board members have any other questions. Seeing none, yes, please, Mr. Brown.
So I'd like to call Mr. Chris Kentop, who's seated to my immediate left. And Mr. Kentop, could you state your name and address and position with Rainbow?
Yes, my name is Chris Kentop, General Manager for Rainbow Disposal. I took the oath, and you want my address?
Just how about yours?
My last name is K-E-N-T as in Thomas, O-P-P as in Paul.
Just your street. You live in Huntington Beach?
I do, I'm Huntington Beach resident,
Okay,
20854 Cabrillo Lane, Huntington Beach, California.
Now we know.
You
where
may
to
not
find
want that on the record.
General Manager.
So there was some testimony during Mr. Thompson's examination on the subject of Rainbow looking for employee parking in other locations because employee parking was one of several factors that impacted whether Rainbow could use the secondary recycling building footprint for construction earlier than it did start construction. So could you briefly describe for the hearing board what you did to try to locate other locations?
So there were two locations in the immediate vicinity. There was a vacant lot immediately to the west of our property, just across the railroad tracks. It's a vacant lot that they used to process pallets on. We approached that owner and he declined allowing us to park our employees there. And then the second place that we looked for parking is there is a parking structure on the corner of Warner and Beach Avenues. It's a 3 or 4 story parking garage. And when we approached them, we were informed that that is permit restricted parking spaces that are designed specifically for a 8-story skyscraper right there. The only people that are allowed to park in that parking structure are employees or customers of the Comerica Bank building.
And did you look at any other sites, or is that it?
That was what we looked at in the immediate vicinity.
All right, okay. Now, I'd like to show you Exhibit CCC, which is entitled Attachment Number 1, Suggested Findings and Conditions of Approval. Are these copies of the conditions of approval that are part of the conditional use permit for Rainbow?
Yes, this is.
Could you turn to the page that has a Bates stamp at the bottom? I think it's 2018. Or do I have the wrong page number? There we go.
2018.
So for the board's convenience, I've bracketed the pertinent language I wanted to direct your attention to. So my question for you, Mr. Kentop, is
Yes,
Since
Senator.
he's discussing Exhibit CCC, we just received it. Should we give it enough time to review it?
What Mr. Bruin is going to do is to walk the witness through the relevant part of it, and then if you would also like some time to look at it afterwards, just let me know, and we'll take some time.
He would decide what's relevant to him, but there may be other things that may be relevant to us, so you have to read it before you know what's relevant.
We need to be given a context of what exactly this document is. I certainly don't know in a vacuum what it is, so I believe he's establishing that through his witness.
Isn't it usually the case where you take time out and review it and then comment on it?
If the entirety of it is relevant, then yes, we would. For example, proposed findings and decision, or a public document, or testimony. However, in this case, I would prefer to have Mr. Bruin lay the foundation, and then if any member of the board would like more time to review it, I will gladly give you more time at that point. Mr. Bruin.
Thank you. So just to go back, now these conditions are conditions that are part of the conditional use permit for your facility?
That's correct.
And they are requirements that the city of Huntington Beach requires you to adhere to in operating your facility?
That is correct.
And does your conditional use permit have a requirement regarding on-site employee parking?
Yes, it does.
And is that requirement reflected in the area of these conditions that I have bracketed for you?
Yes, it does.
And what is that requirement?
It says, you have an underline here, all parking spaces, including truck spaces, shall be available to employees at all times.
So, and how many parking spaces do you have to maintain on site?
A minimum of 256.
So even if you were able to find some other off-site parking, you would have had to go get a special allowance from the city of Huntington Beach to allow you to have parking somewhere else off-site?
That's correct.
Now, I'd like to go back to Exhibit BBB, which is the public notice that Rainbow received from the Air District. And correct me if I'm wrong, but was the requirement that was given to you by the Air District to actually have Rainbow and not the Air District send out this public notice?
That's correct.
And the public notice had to go to all parents of all students at any public or private schools within 1,000 feet of the Rainbow facility?
That's correct.
Approximately how many schools did that involve?
There are 6 of them.
Tell me what the process was you had to go through in getting this public notice out.
There was an opportunity for us to send the notice home with the school children. However, school came to a close before we got the 30-day notice to be sent out. So I started reaching out to the school district in early June, starting June 7th, to meet with them and explore the likelihood of them sending them out for us. The school districts are not allowed to share students' information with us, so we solicited their help in getting them sent out. So we had to create all of the letters, both in English and Spanish, provide the envelopes and the postage for, excuse me, for the 30-day notice to go out.
And who actually addressed the envelopes?
The school district did.
And did you reimburse the schools for that effort?
We paid for all of it.
All right. And so as a result, the very last school sent out the notices on or about July 14th?
That is correct.
So the public notice period ended around August 14th?
August 17th is when the permits were issued, but so August 15th.
Okay, all right. And so within a couple of days, you did receive the final permits?
Yes.
Okay, thank you. One final question. As the general manager, well, let me ask a foundational question first. How long have you been the general manager at Rainbow?
I've been with the company for 23 years, and I've been at this facility since the January 1st, 2017.
So, for example, since the building permits issued in March of this year, you've seen all of the construction at the Rainbow site?
That is correct.
You're there on site every day?
Every day. Yes, sir.
That's where your office is?
It is.
From an operations perspective, is it your opinion that FB&E started work on the secondary recycling building as soon as it feasibly could?
In my opinion, yes.
All right, that's all I have.
Thank you. Ms. Manwaring, do you have any questions?
Yes, just one question, please. In your own words, could you describe what your understanding is of how the parking dilemma contributed ultimately to the delay?
Well, our conditional use permit requires that we have parking for the employees, and it's my understanding that per our stipulated abatement order, we could not impact the community either. So we would have to have some agreed-to parking spaces for the employees that was outside of the immediate community where we work.
But you knew about the CUP before this order for abatement was issued in 2015. So could you say a little bit more about the causation or the connection there?
We knew and continue to know that we have to provide the parking, and we did explore other opportunities and making our best effort to both comply with the stipulated abatement order and our conditional use permit. We, in conjunction with FB&E, worked around trying to accommodate that on site without hindering the construction project to the best of our ability.
Okay, I do understand through your testimony and Mr. Thompson's testimony that there was a space utilization issue. But the requirement for parking spaces was known at the start. So why wasn't that anticipated? Why does parking contribute to delays if in fact you always knew what the requirement was and you always knew what the space was?
Because we didn't know that the city of Huntington Beach would tie our overall occupancy permit to the stormwater infiltration system. We would have been able to work around that if they didn't tie those two together.
Okay, my next question is, I believe you said Comerica? Was that the name of the building associated with a parking structure?
Yes, that's what I know it as.
Okay. Regardless, I trust that that's what it is. Who did you speak with in order to get the information you testified to?
I had a conversation with Ricky Ramos, who is in the code department in the city of Huntington Beach. We were speaking on another matter, and he informed me at that point in time that he had heard that we were exploring that, and then he informed me that that was not possible. It was a permitted restricted space.
Okay, and did I hear you say Mr. Ramos was with the City of Huntington Beach Code Department, Code Enforcement Department?
That's correct.
Is that part of the Community Planning Department?
I don't know the answer to that.
It's okay if you don't know the city structure. I don't want you to guess. But after you were told by someone from the city that there was a city code prohibition, that's when you didn't inquire further. Is that your testimony?
Could you repeat the question?
Was your testimony that after speaking with Mr. Ramos from the city, regardless of which department, that you did not inquire further about that option?
That is correct.
Okay, I have no further questions for Mr. McContack at this time. Thank you.
Thank you. Mr. Camarena.
Mr. Kenkup, notwithstanding the CUP, was there a time when the employees were parking off-site?
No, there has not been, outside of on Nichols Avenue, there has not been a time they've been parking off-site. And Nichols Avenue has been allowable for the entire time that we've been in operation.
And that was acceptable pursuant to the CUP?
The on-street parking on Nichols Avenue, yes, it was.
Was that sufficient to take care of all the employees?
It is not. There are other businesses down the length of Nichols, as well as several of the administration members and schools park on Nichols as well.
Thank you.
Anyone else? Ms. Byrd?
I just had one question. Did you make, or did you reach out to the city to find out what you would have to do to revise your CUP, or were you waiting to find a place first?
No, we didn't wait. I think once we got that information from the city, we redoubled our efforts and tried to figure out how we could accommodate both the CUP, not impact the community, and still continue to work on the enclosure project, which is why we wound up parking where the secondary recycling building ultimately will be.
Okay, I think maybe I didn't ask that question correctly, because that's not the
Okay.
path I was taking. What I'm trying to determine is if you had approached the city about a revision to your CUP prior to securing a location off-site that you might use for parking.
No, we did not. And I think that is, as I said earlier, without knowing that our occupancy permit was going to be tied to having the water infiltration system done, we didn't know that we were going to need to ask for any kind of modifications to our conditional use permit.
Okay, but when you started the process of looking for parking, you knew at that point that you needed to find parking. So that's why I was asking which came first, after you determined that you had to have off-site parking, which came first, approaching the city to see if you could even revise the CUP, or locating a parking facility or structure or location?
When we were notified that the occupancy permit was going to be tied to the water infiltration system, we started exploring other options for parking. Once, at that point, we did not ask for modifications to our conditional use permit.
Okay, thank you.
Mr. Kentop, Mr. Thompson had testified that the green waste processes and all of that needed to be moved to the site for the secondary recycling facility. That's correct?
That is correct.
Okay. Did the addition of parking also in that area also further delay construction on that site? Or was the fact that the green waste was there mean that no construction could move forward on that site anyway?
Just the green waste operation alone would prevent us from doing any construction on the secondary recycling building.
So really, the question of where the parking was moved to and the fact that it was moved to that site really didn't lend to the further delay in construction, did it? Because as long as the green waste processes were there, construction could not commence on that site. Does that make sense, my question?
It does, but I think that it also highlights, or the best way to say it is, it also limits our options to do other things. As Mr. Thompson testified, that we need space to operate safely. We have heavy equipment on site. We have the storage of the actual buildings themselves, in addition to all of the employees and customers that come onto the facility. It limited our ability to move the green waste to other parts of the property, or to start excavation at one point and move into another. So it was an additional factor, I think, that does weigh into the overall site logistics.
But there was no other place aside from that. It was on the south end of the site, correct? Where this?
At the extreme south end, that's correct.
Okay. But there was no other place, it possibly could have been moved around that site, but was there any other place for the green waste process?
No, there is nowhere else that we could put that operation.
Thank you, that was my understanding as well. Those are my questions. And Senator, did you want any time to look at any of these? Okay, Senator has questions.
3 buildings were being constructed at that facility. There were 3 buildings being constructed, right?
That is correct.
And 2 has already been finished, final.
One building has been finished. One building will be finished by November 15th, and what we're asking for is an extension on the 3rd.
Which ones have been finished?
So the transfer station has been completed, which is all of the MSW and green waste have now been moved inside. The material recycling recovery facility, which was a previous structure that is being modified, will be completed by November 15th. Mm-hmm. And then we have started the excavation on the final building, now that we've been able to get the parking lot for the employees and the green waste back inside the transfer.
So you're doing 3 buildings at that facility, at that site.
That's correct, sir.
What's the likelihood that you could have done 2 buildings simultaneously?
In many cases, the work was done concurrently. There are some challenges with having an adequate amount of space for subcontractors to work on. As we had said earlier, that there were restrictions on the air handling system. We had to wait on public comments. And in many cases, you can't complete one process or start one process until another is done.
Right. Which therefore you knew that you could do 1 building at a time. Some of the activities could be concurrent, minor, if that be the case. So therefore, you knew you needed additional parking eventually. As you completed building number 2, did you use some of the parking space for that? Building number 2, yes or no?
No, we did not.
Okay, fine. But you're aware of the fact that there was a negative declaration issued in Huntington Beach in 2008 saying these parking limits are available to you and did not need an environmental impact study in order to provide it to you. That's what a negative declaration really signifies. You understand that? That's what a negative declaration.
I'm not aware of that, but
This
Senator,
5B.
Mr. Kentup is new to California, and he's probably not an expert on the,
Or you an expert
fine
on that?
points.
You can tell us about a negative declaration?
I don't think I'm an expert on anything, but I know a little bit
I
about it.
mean, this is what you boxed this out and you highlighted it and you opened a discussion on this issue.
Yes, this is a condition that's part of the conditional use permit, that after environmental review is imposed on the facility operations to prevent there being a significant environmental impact due to traffic and parking.
Therefore, it was not a significant impact. Therefore, a negative declaration was allowed based on declaration number 06-006. You got it. That's what you got right here.
Yes, sir.
Okay, fine. So, and you're allowed to use 256 spaces at that time, 2008. When did you exceed the need for 256 spaces?
we currently have 305 employees. However, many of them commute via public transportation, live within walking distance, or ride their bikes. So we have always been challenged with parking, truthfully, and this having to complete the water infiltration system while we were doing construction compounded that problem, sir.
Once again, you're new in California, but there's a plan for which companies can provide for carpooling and compensate the employees when they carpool financially and otherwise.
I have heard about, I don't know about it in great deal, other than having heard that it's something that companies do, sir.
Yeah, given the fact that you're going to be have a need for additional parking, was it ever suggested to your employees that they carpool?
In many cases, employees do carpool. They have long commutes. They come from the Inland Empire, other places as well, but I don't know to what extent. That I can't speak to, sir.
So therefore, the 256 spaces are adequate at some point.
I think that parking is tight now, and it is adequate when we are not doing construction or have to do any mass excavation, yes.
When you eventually set aside some greenway for parking and for another building, you knew in advance, did you know in advance that was going to be a likelihood, the action that you would take in that regard for parking would be maximized?
It would have happened in a different sequence if we knew that we were going, that water infiltration was a concern, stormwater is something that we need to address. But the fact that it was tied to meeting this completion date is where we've run into problems. It was just really about accommodating all of the construction, minimal impact to the community, getting everything done at the same time is where we ran into a challenge.
I believe you testified that it was unlikely that you would do both buildings at the same time concurrently. So the adequacy for space availability was not there for concurrent operation, for construction.
I'm sorry, I don't understand the question.
I'm not sure I do either.
Well, you testified that you were not likely that you could construct both buildings at the same time.
When I said concurrent construction, in both cases, we were modifying existing structures with the exception of the green waste area. So green waste was moved to the south side of the property, and then we started to construct around a previously existing footprint, which is the same thing that we had done in the material recovery facility. No major mass excavation happened concurrently with any other building, which is what wound up impacting our ability to start this third building. The mass excavation is what is the biggest challenge.
As you managed the construction of these three buildings and became aware that you needed additional parking space, what action did you take prior thereto? Because the planning is in advance. The planning is in advance for managing the project.
It is. The plan that was submitted initially to the Air District did not include the water infiltration system. That was tied into the project by the city of Huntington Beach, so that is when we had to make changes.
Just for clarification, the issue that is being presented is not that the 256 spots on an ongoing basis are not sufficient. It's that all 256 spots were removed from while there was excavation going on for the stormwater, and all of those spots had to be resituated somewhere else. Is that correct?
No, a portion of them had to be
Okay.
resituated.
How many?
90 spaces had to be resituated.
Okay. Thank you for that clarification. Anyone else have any questions? No? No? Oh, Ms. Memory.
The district has a follow-up, please, if you'll permit us. Chris, could you please state your name again? I keep mispronouncing it.
It's Chris, C-H-R-I-S, Kentop, K-E-N-T-O-P-P.
My apologies, Mr. Kentop.
Nope, quite all right.
My question to you is, at any point did Rainbow consider temporarily ceasing the green waste operations in order to open up room for those 90 parking spots?
No, because we have contract requirements with all of the municipalities we serve. And we also have requirements to divert a certain amount of, greater than 50% of the material that we collect per cal recycle. So in order to fulfill our contract requirements, we could not cease operation.
And if you had failed to fulfill the contract obligations, would there have been a penalty or a consequence of some sort?
Yes, there would have.
Do you know what that is?
Well, I don't know what they are exactly, but we do indemnify the cities, and we are responsible to ensure that we're doing our part to make sure that the cal recycle requirements are met.
Could you say a little more about the cal recycle requirements? Is that something enforceable through statute?
I believe that it is. So civil penalties are assigned if cal recycle's diversion requirements are not met.
All right. You're not a lawyer, so I just want to ask, are you certain that there are civil penalties associated with the diversion requirements?
No, I am not 100% certain. I am not a lawyer.
But we're certain there would be contractual consequences should you fail to meet your franchise agreements with the city.
That is correct.
Was there any capacity to reduce the operation and still meet your obligations?
Actually, we did. So we restricted throughput by almost 30% to try to work around just the overall construction project.
And how did you determine that you could reduce by 30% and be in compliance, but not eliminate? How did you determine that you could reduce by 30% and still be in compliance?
It's a volume calculation, so we know that the amount of green waste that we accept that is accepted by Cal Recycle to be used as ADC is what we, it's just a function of the volume that we take in order to hit that requirement. So it was just a mathematical formula.
Okay, so is it your testimony that you reduced the green waste operations as much as was feasible based on the information you had?
Yes.
Okay. No other questions for Mr. Kentop?
Thank you. Mr. Camarena.
Yes, I have a follow-up on that. Had you failed to live up to your contract, what would the municipalities have done with their green waste?
Well, that is a good question. If they found us in breach and they didn't take it to us, I don't know what they would have done with it. Green waste, in my opinion, is an issue that the state's going to have to face going forward. There's regulations that are going to be in full effect by 2020, and what to do with this material is a dilemma that we have to work out in cooperation with the waste management districts and the cities we serve.
Might that have gone elsewhere?
Potentially, yes. It could have.
Senator.
You do business with the city already, permit, so on. They know, they were aware that you're going to build 3 buildings in that area, facility, for good cause. And you were aware at least, that you'd be limited by parking. My question is at any time that you request from the city a variance as relates to parking, variance from that mitigation?
No, we did not.
Why not?
Well, because the infiltration system being tied, or the overall occupancy permit being tied to the infiltration system, it was a function of timing. We didn't ask for any modifications. We worked around it, honestly.
Your parking was a limit. You're limited on parking. And that's what you need a variance from the city for. They locked you in with the mitigation order. Now, did you request a variance from that?
I did not.
And why not?
We
Have you
believe,
gotten it?
sorry, sir. We believe that in doing our best effort and due diligence, accommodating it on site without impacting the community and without asking for a variance was the best course of action to take.
Well, that's on you. Thank you.
Anyone else? Mr. Bruin, any other witnesses?
No.
Okay. And Ms. Manwaring, you have no other witnesses?
Correct.
Okay. I don't believe there's any member of the public who wishes to be heard, but I will go to the public. Seeing none, Mr. Bruin, I'm going to ask for your closing at this time. And if you could succinctly, if possible, in your closing, tell us precisely what the modification is that you're requesting, not just the date, but where in the order you would like to see the modification and any wording. That would be helpful.
Well, I was envisioning that this could be done by a separate document, which would make the finding of force majeure and would grant an extension for completion of the secondary recycling building to May 30, 2018, with all other terms and conditions of the abatement order to remain in effect.
May 30, did you say May 30? Because I thought the request, I know it's a day, but was for May 31st? Is that
I believe there are 30 days in May. We were,
30 days has September, April, June, and November? No, May has 31.
was it F-31? Then, well, if we can get an extra day, that would be great.
And can you clarify your position as to whether force majeure finding needs to be made in order to grant the extension?
Well, my belief is that the board could, in theory, grant the extension but not make the force majeure finding. However, the reasons for the extension are based on force majeure. So it seems to me, am I giving my closing now?
Why don't you give the closing? I just wanted, because you suggested that and I had asked for the wording.
Ms. Manwaring asked for maybe a short
Should we
break.
take a break
apologize.
now?
Could we
That-
take just a short break before the parties present their closings?
Why don't we take a 15-minute break, and that should give sufficient time? Okay, so we're off the record until about 10 after the hour.
Thank you.
Sorry, yes, 10 after the hour. We're back on the record. Mr. Bruin, are you ready for your closing?
Thank you. Madam Chair, members of the hearing board, when the abatement order was first issued, Rainbow was placed on a tight schedule. In fact, that schedule had the transfer station being completed towards the end of November of this year. We negotiated with the staff, and the hearing board approved this, a force majeure clause, which said that if there was an act of God, such as extreme weather, if there was a delay in a permit needed for these buildings despite our best efforts, those would be force majeure events. We have proven that 2 force majeure events occurred, one being the excessive rain, 38 days lost, working days lost last winter on the transfer station foundations. I mentioned that the Rams Coliseum was delayed a year because of the extreme rains. That's a force majeure event. The building permits are defined in the abatement order, if they are delayed despite reasonable efforts, as a force majeure event. What is the evidence that the building permits were delayed despite our reasonable efforts? First, you have the testimony as well as the declaration of Mr. Thompson about the various complexities in this project, his 42 years of experience in the construction industry, the fact that Rainbow worked as hard as it could to process these permits, but there were additional unanticipated requirements imposed on the project by the city of Huntington Beach that were not known at the time the abatement order was entered into, including, most importantly, the requirement that the infiltration basins be installed under the employee parking lot, which definitely affected the schedule for the secondary recycling building, which is the subject of today's hearing. Mr. Thompson testified that since the beginning of this project, Rainbow has worked nights and weekends and double shifts to expedite construction as much as possible. They have not spared anything in terms of trying to complete these buildings as soon as possible. And I respectfully submit it is a testament to their due diligence that despite a 7-month delay in the building permits, they were able to complete the transfer station and are almost going to, basically on the verge of completing the material recovery facility, and will have both of those buildings done by November 15. Now, why is that important? You may recall from the evidence before this hearing board that the community's issues with Rainbow were odors. And the big sources of odors at Rainbow was the garbage transloading operation inside the transfer station and the outdoor green waste processing operation. Today, the abatement order has worked. Those operations are fully enclosed in a Rule 410 building, and that was the primary source of odors at this facility. A secondary, and in fact, somewhat far in the distance source of odors was the material recovery facility, which took in mixed recyclables. That building will be fully enclosed in a Rule 410 building by December 1. The only building yet to be built is the secondary recycling building, and the construction and demolition debris operation has not, by the community or the school district, been criticized as a source of odors. It hasn't been stated to be a source of odor NOVs, and the history, the testimony, I should say, before this hearing board was that Rainbow has never received a notice of violation from the Air District for dust, and Min Soo testified at the original hearing, if any visible dust were seen leaving the C&D area, we would have received an NOV, but none have ever been issued to Rainbow. So the fact that there was a 7-month delay in all 3 buildings getting their permits, and we only need a 6-month delay for the least important building in terms of odors, is a testament to the fact that Rainbow and its contractor have done their very best to complete construction as fast as they could. And you don't have to just take Mr. Thompson's word for that. You have the declaration of Scott Hess, who's the Director of Community Planning for the City of Huntington Beach. And what he says is that Rainbow used due diligence and best efforts to get its building permit as soon as possible. He's observed the construction at the site, and it's his testimony, in his declaration, that Rainbow has pursued construction with all due diligence. And indeed, again, the facts show that. But I think most interesting, and perhaps most telling in a way, is that Rainbow's adversary, the Ocean View School District, two of their representatives stood before you, and what did they tell you about Rainbow's efforts to obtain building permits from the city? Gina Clayton-Tarvin testified that both she personally and her staff checked with the city of Huntington Beach and were told that the delays in obtaining the building permits from the city were not Rainbow's fault. So you have independent verification of what Mr. Hess has stated in his declaration, that the delays in getting the building permits, a force majeure event as defined in the stipulated abatement order, was not Rainbow's fault. Rainbow did its best to get its permits as soon as possible. Mr. Briscoe testified that he campaigned for the infiltration project, and he took responsibility for the delay in the project resulting from the infiltration basin. Gina Clayton-Tarvin and Mr. Briscoe both said they fully support Rainbow's petition. They ask that you grant it. No members of the public have appeared in this hearing to protest this petition. It's interesting, you probably recall how many people were here in the original hearings that were complaining about Rainbow. We haven't received an odor NOV in 18 months due to our attention to the requirements of the stipulated abatement order. That says something implicitly about Rainbow's best efforts and good faith. Now, you did hear testimony from Ms. Shibata, who said there were 24 separate permits needed for this project. It was a very complex project. The district has only done 2 prior Rule 410 permittings, and she was not involved in them. This is her first one. She said that, and I did an overnight transcript, so I checked her wording. She said Republic was, quote, extremely responsive to the district's request for information. She said this was a very complex project, that it took 18 months for the district to issue its permit, and that 18 months was not unusual for a project of this complexity. Most importantly, she said she knew nothing about the building permit process before the city of Huntington Beach. She wasn't involved, she didn't talk to the city about it, so she really had no evidence that bears on the question of whether Rainbow's used its best efforts to obtain the building permit from the city. No one has taken the witness stand and stood before you under oath to say Rainbow is responsible for the delay in the building permit. They didn't use due diligence. They didn't use best efforts. None of that evidence is before you. So the evidence is uncontradicted, I submit, that there was a 7-month delay in the building permit. There were 38 days lost due to rain working on the transfer station foundations. Those events qualify as force majeure events. Now, the second question is, well, did those force majeure events result in a delay in completion of the secondary recycling building? And the answer is yes. There was really a cascade of factors resulting in putting the transfer station first priority to build, the material recovery facility second, and the secondary recycling building third. Of course, that was done because everybody knew the secondary recycling building did not address the main source of odors that had been the complaints regarding Rainbow, so the board wanted to address green waste processing and solid waste transloading first. We agreed to that. We said we'd do it. But what that meant was, in order to build the transfer station, we had to move the green waste processing area over to where the secondary recycling building would be. Because we were dealt the hand of having to do this extensive infiltration work during this summer, we had to move those parking spaces over where the secondary recycling building would be. At the same time, we have construction and demolition debris processing going on. We have the soil stockpile from the excavation of the infiltration basins underneath the parking lot. That soil had to go somewhere. It went over to where the secondary recycling building would be. The testimony, again uncontradicted from both Mr. Kentop and Mr. Thompson, is that but for these force majeure events, the secondary recycling building wouldn't have been delayed. But because of those events, because the area for the secondary recycling building had to accommodate parking, green waste processing, material storage, rights of way for vehicles working on the site, the facility could not stay in operation and do the secondary recycling building any sooner. Well, you might say, well, let's shut the facility down. Why couldn't you have just stopped all operations, stop collecting garbage, stop collecting green waste, have it go somewhere else? Well, first of all, that really isn't practical. And second of all, the stipulated abatement order never required a shutdown of the facility. Actually, members of the hearing board said they didn't want to shut Rainbow down. They wanted it to continue to fulfill its public service function of dealing with solid waste, green waste, and recyclables. So I submit to you there ought to be no implied obligation on Rainbow to have stopped operations to facilitate construction. The whole idea behind the stipulated abatement order was to facilitate operations, the continuing operations, as well as get these improvements done as soon as possible. I have submitted a memorandum of law to you which defines due diligence and best efforts. And if you look at that memorandum, it says that best efforts require that someone do what a reasonable person would do, a reasonably prudent person. It doesn't require Herculean efforts. It wouldn't require something as drastic as shutting down the facility. So I submit to you that we have shown through uncontradicted evidence that a force majeure event has occurred, 2 of them, extreme rain, and the delay in the building permit, which has led to our request to you for more time to finish the secondary recycling building, and only that building. So one might say, well, let's give Rainbow an extension. After all, they've shown to us that it really wasn't practical for them to get this building, all 3 buildings, done on time. But let's not make the force majeure finding. Let's have the district fine them $250,000. Well, I guess my first answer to that question is why. The stipulated abatement order recognized and acknowledged that if force majeure events occurred, the board should make a finding. And we're before you asking for a finding continuing completion of the secondary recycling building because of 2 force majeure events, not because of something else. So logically, I don't see how the board can say, well, you've convinced us that because of all of these things, the delay in the building permit, the rain, you can't get the facility done on time. We'll give you the extension, but we're not going to make a force majeure finding. To me, that's illogical, because to me, both findings go hand in hand. Second of all, the intent of this agreement was that we were on a very tight schedule. I mean, the board knew that. And the board said, if you got a problem, come back to us. That's why we're here today. That was the intent of the building, of the stipulated abatement order. Third, I just want to remind you that if the Air District were permitted at this point, because you didn't make a force majeure finding, to impose this one-time penalty of $250,000, then that penalty goes away. It gets paid. If you extend our time to build the secondary recycling building and make a force majeure finding, the penalty doesn't go poof, it's still there. Under the terms of our settlement with the Air District and the terms of the abatement order, if we miss the May 30th, 2018 deadline, we'd have to pay that penalty. So that's another reason to keep it there and to make the force majeure finding. I'd just like to say that if you look at this project as a whole in terms of the big picture, my client committed to enclose more than it had to enclose under Air District regulations and rules. It enclosed the C&D operation, which could always occur outdoors under Air District rules. We agreed to enclose the green waste operation, which today is enclosed, which can operate outdoors under Air District rules. The complexity of this project has grown from $11 to $20 million, showing indeed how difficult it's been and how expensive it's been working double shifts, working weekends, working nights. We made peace with the Ocean View School District, which really was the instigator of this abatement order. You heard two of their representatives supporting our petition before you, and no members of the public opposing it. So for those reasons, I respectfully request this board extend our deadline to complete the secondary recycling building to the end of May of 2018 and to make the force majeure finding based on excessive rain and the delay in the City of Huntington Beach building permit. Thank you.
Thank you, Mr. Bruin. I do have a question before I ask Ms. Manwaring for her closing. I do understand the position of Rainbow wanting both a force majeure finding and an extension. My question, though, is your position on whether this board, under the existing stipulated order for abatement, has the ability to grant the extension without the force majeure finding, given that the order does include a condition, condition number 16, with regard to modifications and the requirement of when to notify the board as soon as possible of the request, that we generally can make that finding or make extensions based on a good cause finding. And the force majeure is not a condition of the order itself, but rather, or tied to condition 16, but rather is in the factual portion of the findings and decision. What is your position on that? Can it be done just on good cause? I understand what you would prefer, but.
Well, I think it's pretty clear that the board has the plenary authority to find good cause to grant an extension without making the force majeure finding. My argument is, logically, I think both findings ought to be made based on the uncontradicted evidence.
Understood. Thank you. I just wanted to be very clear for all board members. Ms. Manwaring, your call.
Thank you, Chairman Prusak and members of the board. As a preliminary matter, I'd like to move Exhibit 10 into evidence. That was the permitting timeline prepared by Ms. Shibata.
Any objection?
And I have no objection, and I'd like to move Exhibit DDD, which I forgot to do, in evidence.
Any objection to that?
Remind me which one that
It's
was?
the use permit conditions.
CCC.
I'm sorry, CCC.
Yeah. No
Okay.
objection.
So since there are no objections, Exhibit 10 and Exhibit CCC are moved into evidence.
Also, as a preliminary matter, I'd like to also answer the legal question that you just raised.
Yes, please. And I do recall, I thought in your opening that you did say the answer I thought is the answer, but please.
This board can modify an abatement order on a finding of good cause. Good cause is something different and separate from force majeure. When the parties negotiated this and agreed to asking this board to decide, we anticipated that it was something different and distinct from. So absolutely, you can grant a modification to the order for abatement based on a finding of good cause, based on the evidence and testimony you heard. Yet does not mean that you have to, logically or otherwise, also make a finding of force majeure. And in my closing today, I will implore you to not make that finding. The district objects to this board making a finding of force majeure based on the evidence and testimony that we've heard. It's an interesting question that we put before you today, but I don't agree with how Mr. Bruin set up the issue. He says that 2 force majeure events occurred, and that is sufficient and almost illogical to decide otherwise. But from paragraph 26 of the order that you issued, you agreed to define force majeure to include the inability, despite respondent's demonstration. I want to be real clear that that's in there. Respondent had a burden today to demonstrate that it exercised due diligence and best efforts. I am not going to sit here and bash Rainbow Republic for their efforts here. This is a good project that's making the community satisfied. But I'm also not going to pretend they're doing this because they're altruistic. Lawyers negotiated an agreement. Lawyers anticipated problems. Lawyers created clauses to address anticipated problems. What I would like you to consider today is what evidence did you hear that connects the delay to the request? We heard a lot of information about the fire department, but that was known and those protocols took a long time, and no causation, no connection that that actually caused a delay. We also heard a lot about parking and how that was difficult. I'm not convinced that establishes a causation, because the only evidence you have that directly speaks to the delay are the Public Works Department required approval of a water quality management plan and a stormwater management plan as part of issuing the building permits. What evidence did you hear about the Public Works Department? You have a declaration from planning, but that's different and distinct from Public Works. What you heard was that they knew about those requirements, but they did not anticipate that that the city would require those approvals as part of the building permits. What else did you hear about those plans that are specifically at issue and being claimed to have contributed to the delay? You heard from Mr. Thompson that 4 or 5 plan checks. But you also heard, when I questioned, is it simultaneous? Are they different? Is stormwater and water quality a different submittal? And I did also, I don't have the transcript like Mr. Bruin does, but I did go back and listen to the testimony. And I quote, Mr. Thompson said, if one was submitted more than the other, I don't have a specific recollection. Their key witness on what the delays are doesn't know how many times these plans were submitted. We know that they were submitted at least 4 or 5 times. And you also heard very interesting testimony that is extremely credible from the district's permitting engineer. This facility was extremely responsive, but not very accurate. And accuracy, when you're calculating inward face velocity, is essential. Ms. Shibata gave you an example where they omitted 40% of the open space. She had to catch that mistake and go back to them. We have no idea if similar mistakes were made with the Public Works Department. And whether or not similar mistakes and delays were with the Planning Department, I don't know, because Mr. Hess wasn't here to cross-examine. There are a couple issues that you did hear more about, including litigation. And you also heard testimony from 2 different witnesses that things improved when Republic became involved with the communication. Ms. Clayton Tarvin testified that there came a point where she would pick up the phone and call the facility directly because she trusts them now. You also heard the engineer testify that things improved when Republic came on board, specific to the administrative tasks associated with the later permitting applications. Would things have been more timely or run more smoothly if Republic had been brought on sooner? I don't know. You don't have the evidence or testimony before you make that decision. But you also don't have evidence or testimony about what happened at Public Works and why they had to submit multiple plan checks, or how many plan checks they submitted. With regards to the litigation, you heard testimony about a $4 million contribution to build the school district's gym. That's fantastic. I don't want to punish this facility for resolving litigation or contributing to a public work, but at issue is money. That's what's at issue today. You can grant the extension without making the finding. If you do, there's a penalty. There's 2 key bits of evidence that I heard when I was listening about the litigation. 1, the litigation did result in design changes, improvements even. You heard that from Mr. Thompson. You also heard testimony that changes in design were reasonable, but the permitting engineer also testified they were often inaccurate. Did the litigation contribute to the delay? Is that something that should be relevant before you today? The facility presented an argument that they were not aware that water quality plans would be required as part of having building permits issued. I posit that we did not hear enough evidence today, and respondent failed to demonstrate that they exercised due diligence and best efforts as to the Public Works plans they claimed caused the delay. Why 7.5 months delay? How much of that time was submitting and resubmitting plan checks? I don't know. They failed to meet their burden. With that, the district would urge you and object to a decision of force majeure based on the evidence you heard. If you do decide to grant the extensions based on the evidence establishing good cause, we would object to you further finding that a force majeure event occurred and that respondent has demonstrated best efforts and due diligence in response to that force majeure event. Thank you.
I have a brief rebuttal.
We don't usually entertain rebuttal. I'm going to ask Ms. Manwaring if that would be appropriately okay with you.
As long as we're respectful, do I get to rebut the rebuttal?
Yes.
We'll do two short rebuttals.
Right.
And if
From the beginning, the district has wanted this board to be fully informed. I have no objection to Mr. Bruin's rebuttal.
And may I just ask Ms. Manwaring, and I'm sorry, because I was taking notes and reading things while you were closing. The position of the district on the extension itself was that stated?
No, I did not state a position on that. I said, if you do determine you can find good cause, I would object to the second finding.
Okay, so the district has no position on the granting of an
I
extension?
think there's clear and convincing evidence. They're not going to make the December 1st deadline as to all 3 buildings. If you agree that's good cause to extend the deadline, I would not object to that finding.
Okay, thank you. Mr. Bruin?
And I'm wondering, before Mr. Bruin does his rebuttal, because he may want to address this, there is a legal significance to that. If the extension is not, I apologize if I'm going out of turn here, but if the extension is not granted and the December 1st deadline is not met, the facility faces being in violation of the abatement order and faces a daily penalty. That daily penalty would quickly become much larger than the litigated damages,
Thank you.
based on the schedule presented. So there is a legal significance to a bifurcated decision.
Thank you. Mr. Bruin?
Thank you. I'd like to comment on Ms. Manwaring's criticism of the showing that my client has made that it used best efforts to get its permit from the city as soon as possible. Scott Hess was in charge of the Community Development Department. That's the department that issues the building permits. And he's testified that Rainbow used its best efforts and due diligence. You've had Mr. Thompson testify before you, and he's been cross-examined. And if Ms. Manwaring wanted to ask about the reason for a plan check or anything specific, she was certainly free to do that. To make a showing before this hearing board, we've given you a fairly detailed declaration from Mr. Thompson stating that my client used its best efforts and due diligence to get the permits. It was a complex project. There were a lot of elements involved in conforming the building permit to the conditional use permit. There were aesthetic requirements. There were fire department requirements. There was the infiltration requirement. And Mr. Thompson said they first found out about the need to install the infiltration basins in August of 2016, didn't get the sign-off from Department of Public Works until February of 2017. Sure, we could have spent 2 days going through each plan check and telling you why it was made. But I don't think that would have really been of any use for this hearing board. You're not construction experts. You're not going to really know whether or not a design change, which was requested by the city, was reasonable, or how long it took an engineer to do the plan revision, or any of that kind of detail. So really what the district is doing here is they're speculating. They're saying that because Ms. Shibata found an error in this one calculation regarding the envelope of the building, you ought to presume we made a bunch of errors in applying for the building permit. It's just speculation. Now, yes, we could have put on evidence regarding that issue before the hearing board. We could have told you that there was a difference of interpretation over how to calculate the envelope of a building under Rule 410. It's not a mistake, it's an interpretation. But we told you from the beginning we weren't challenging the time it took the Air District to issue its permit. So I didn't want to spend half a day arguing about the timing on the air permit when that wasn't relevant. So now for Ms. Manwaring to ask you to speculate that, well, maybe we did a bad job in applying for the building permit, or we had too many plan checks or something else, when there's no evidence of that, I submit to you, you should go on the evidence before you today. With respect to when did Rainbow get purchased by Republic, Republic owned Rainbow In November of 2015, when you adopted the abatement order, it wasn't a subsequent event, and this board knew that. There was testimony to that effect. So again, there was a 7-month delay in the building permit for all 3 buildings. We're asking for a 6-month delay for only one of the buildings. That's all I have. Thank you.
Thank you, Ms. Manwaring. Did you have a further rebuttal?
Thank you. Yes, and I will keep it very brief. To be clear, it was never my intention to raise any issue about the purchase of one corporation by the other. What I was reminding this board is that you heard testimony from 2 different witnesses that at some point things improved. Could they have improved sooner if that change had been made sooner? It had nothing to do with the purchase date. Second, I do take issue with Mr. Bruin's recollection of my questioning of Mr. Thompson with regard to these water quality issues. I asked several questions. He was not in a position, an informed position, to answer those questions. That is relevant evidence for you. This is the expert that's here to describe what they did. The plans at issue are very specific, and there was no testimony and no recollection about what those issues were. Nobody asked Rainbow to come in here and talk about all the different design changes and how one plan checks everything. You had a burden to demonstrate that best efforts and due diligence were demonstrated. And the district is calling into question the relevance of the declaration from the planning department when the plans described it causing the delay were out of a different department. I do think I questioned Mr. Thompson at length at that, on that issue, and I have nothing further. My apologies for my lack of brevity.
I think it was an adequate and reasonable amount of time. Board members, let's first start by framing the issues that are before us. I also think we should start first with the force majeure. And the reason why I think that is because if we make that finding, we would definitely be able to make the finding of the extension. If we do not make that finding, then we first would discuss good cause separate and apart from force majeure. I also want to begin by framing more succinctly what finding the stipulated order for abatement anticipates this board can or will not make when requested by the respondent with regard to force majeure. I'm going to read from it is in exhibit, if we don't have it in front of us, so everyone has it in front of you, Exhibit YY, which is the big folder that we were given at the last hearing, and the order as it stands currently is under tab 2 of Exhibit YY. And I am specifically looking at paragraph 26 of the finding, not of the order portion, which is on page 8 at the very bottom. And it begins, paragraph 26 begins at line 24. But the finding and how it's phrased that we need to make today begins on line 26. I'm going to read it. In the event that a petition for modification of the requested order is filed that asks this hearing board to make a finding, and the finding that we would be requested to make is that delay was the result of a force majeure. The parties have agreed to the following definition. So the finding we need to make is not merely that there was a force majeure or 2 force majeures, one being excessive rain and 2 being the 7.5-month delay on the City of Huntington Beach permit. We must also find, for it to be relevant, that any delay was the result of said force majeure. So, in fact, we would need to be able to make the finding of force majeure, and we have to find causation, that force majeure or any delay, any extension requested and delay that is the result of the requested extension, that has to be the result of that force majeure. With regard to any act of a public agency, as Ms. Manwaring was stating in her closing, we need to make the further finding that the inability, sorry, let me just read it. Force majeure includes any act of, doesn't matter, or agency, or the inability, despite respondents' demonstration that it exercised due diligent and best efforts to obtain a permit necessary for construction or occupation of the proposed improvements. So that is everything. So if number one, we need to find that there is a force majeure, or that there is some inability to have a timely permit that is not the fault of respondent, and that the respondent exercised due diligent and best efforts. But also we need to make the finding that if that is the case, and there was best efforts, that delay resulted in the delay in the request for an extension. I hope that that's clear. So there are two very separate things we need to find. I'll open the discussion. I think the question of diligence is a difficult one. I also think the question of the causation is also a difficult one, and that's the one that I've been struggling with. It's the one I struggled with when I first received the documents for this case in advance and read them all of the declarations. My question was, okay, I see all of these various things, but I do not see how they tie together to show the 7.5-month delay and the 6 months that are requested. We then received further testimony, and if I may, board members, please correct me if I am wrong, because I'm still struggling with it, but my understanding of everything that I heard was that the reason why construction of the secondary recycling facility is not on schedule is because of the limited space on this facility and the need to move the green waste operations to the south end within the footprint of what will become the secondary recycling facility. Mr. Thompson testified that green waste, that those processes were moved, that all of that was moved January, February of this year, 2017, and they were, well, as of last week, they had been moved just 2 to 3 weeks prior to that, off of that area, and thus construction could begin. And it seems to me that is the reason why construction could not begin on time. And that is tied to the fact that this board had asked that the priority be the odor-producing facilities, the transfer facility, and the other two buildings. And so that was moved there for staging. I haven't heard any evidence, and in fact, I asked Mr. Thompson if the permit was received earlier, could construction have commenced there, given that the green waste was, and my understanding or my recollection of the answer was, no, the green waste had to be moved. So to me, that is the causation. And then today, Mr. Bruin, in explaining why, or respondent in explaining why they waited until now to ask for the modification and the extension, what we received in response to that question was exhibit, I think it's BBB, and an explanation, yes, BBB, an explanation that the district's permitting had a 30-day public comment period, and it wasn't very clear how long that would take and what else would be included, and when the green waste could in fact be moved from this facility, or this section of the property, the south end of the property. So my understanding of that is that green waste is there, it's been there since January, February, and it couldn't be moved until the district issued its permits, which is not tied to the City of Huntington Beach permits. So I'm not seeing the causation, and and as a result of that, I don't believe we can make the finding that is being requested and that is outlined in condition, or not condition, in paragraph 26 of the findings. Ms. Byrd?
Ms. Busek, are you not including the rain as a act of God, the excessive rain in this past year? Because my understanding was some of the construction was not completed, which also then bumps everything else back based on not completing one building, since they can only complete one at a time. And so there was, as part of this, the idea of the excess rain. Now, the other part I haven't gotten to yet either, the due diligence and all that, but the excess rain. And I know that there was excess rain because I spent a few days floating around on the freeway in this past rain season. So are you not including that as part of it? They couldn't move the grass. They couldn't move the green grass until they finished.
Yes.
And they couldn't finish because of the excess rain.
This is where I don't believe the demonstration was aptly made, because I'm still sitting here in utter confusion. What caused what? What's the reason for what? It should be clear if the demonstration had been made. I do believe that many things happened that changed how the construction progressed, including the delay on the permitting from the city of Huntington Beach, thank you. The rain. In fact, I was thinking, well, why the particular thing that they were working on at that rainy part of the time of year was, I don't remember exactly what it was, but was the holes in the ground and the casings, thank you. And I had thought to myself, well, why were they doing that then? Could they have done it another time? And I do see that the answer is because that was about the time that the city of Huntington Beach allowed them the foundational permit, and so they couldn't help that timing. But even with that said, receiving or hearing the testimony with regard to, unless I'm understanding it wrong, Exhibit BBB, which had to do with the 30-day public comment period and the timing of the district's permits, is that green waste, regardless of whether there was some kind of delay in any part of the project due to rain delays or permitting or anything from the city of Huntington Beach, that green waste still could not be moved until that 30-day comment period were completed, and if comments had been submitted, a response to those comments, and those permits granted. So hearing that testimony today made me think, I still don't see the causation. I'm having a hard time even seeing the causation for not commencing construction in this area. I still see it's the green waste, and I don't see it specifically tied to either the rain delay or I'm not saying they don't exist, and for me, good cause is a totally different issue than force majeure. And just to say where I'm going, I do believe I would be able to find good cause for the extension, but I'm having a hard time with the force majeure finding. Mr. Camarena.
Yes, I have a question of you. Is there any evidence you can cite that would indicate that the respondent has not exercised due diligence and best efforts?
I think that's the wrong question. I think I have to agree with the way it was framed by Ms. Manwaring, which is to reread, it's on page 9, as part and parcel of the finding we need to make and the definition of force majeure as it is written in the stipulated order for abatement. It is respondent's demonstration that it exercised due diligence, not a lack of evidence that they did not exercise due diligence. So as far as due diligence is concerned, we haven't really talked about that much. I'd be interested in hearing about that. I'm more stuck at this particular moment on the page before, that the delay was a result of force majeure, because that's the very finding we need to make, aside from defining whether force majeure actually occurred. But I do think that there are a lot of questions with regard to due diligence. I do think we received Mr. Hess's declaration, Scott Hess, that is Exhibit 4, but it's a question as to whether the planning department is the same as Public Works. Also, it is hearsay. It was not subject to cross-examination. But we did hear from Mr. Thompson, as Mr. Bruin points out.
I understand that the burden is on the respondent regarding the demonstration of due diligence and best efforts. Would make my decision easier if there were any evidence to indicate that it had not exercised due diligence. With respect to Mr. Hess's declaration, it was made under penalty of perjury. It was accepted in evidence, but as you point out, he was not here for us to cross-examine, and that's a little bit of a problem.
And just, I'm sorry, and I don't want to interrupt, but just to point out, the board may accept that evidence. First of all, Ms. Manwaring did waive the right for cross-examination for Mr. Hess. Second of all, we can accept hearsay evidence and we can accept declarations, although parties independently have a right to cross-examination. But again, Ms. Manwaring did waive that. But we cannot base a finding solely on hearsay, and I would say that that is hearsay evidence. Ms. Bird.
I was under the impression, and I think we questioned the district initially as to why Ms. Shibata came before us and testified to what she testified to. And what she presented appeared to be what you're saying, is that her testimony was to say that no, they had not conducted due diligence. That's the impression I got from her testimony, because she then went forward to say that there were mistakes. There was 40% information or 40% difference in, I think it was the surface area of the building. And to me, it almost sounded as if that was the rationale for that testimony, is to show that perhaps Rainbow had not done all they could have done, because they didn't, to show that maybe one thing translated to another, that they didn't provide it for the district, and perhaps they didn't provide it overall, and that might have been part of their reason for not moving forward. That's the impression that I got.
I did not get that impression. Certainly there were errors, and at least one substantial error. An error does not, to me, indicate a failure to make best efforts to exercise due diligence, because errors do occur, and especially in a project that is changing as a result of a number of permitting entities being involved, and the pressure on the provider of the information to provide it promptly, and that can lead to errors, and apparently it did. So I didn't interpret Ms. Shibata's testimony as indicating failure to exercise due diligence and best efforts on the part of the respondent.
I will say that I am on the fence. I am not. I based on what we have here, and this is the definition that was put into the order, I think that it's prefaced, the first line of number 26 specifically says, given the number of regulatory agencies involved and potential for events beyond the reasonable control of respondent, the parties recognize the necessity to extend the final compliance deadline of December 1st, 2017 may arise. That sentence in itself makes me believe that this order was crafted with the idea that we're going to be changing it, or that the potential for change is there because of the number of regulatory agencies involved and events that could happen that are beyond the control of the respondents. And I know that we don't always have this statement in an order. I know it could be put in any order, but that statement in itself makes me believe that there was some anticipation that there would be a change in this final compliance date.
I have to stop. I have to say, they still need to meet the burdens set
Right.
forth in there, and we still need to be able to make all the findings that are required in there.
Okay, and for me, the rain and the cascading effects after the rain, I don't know that, I haven't reached the conclusion that it would cost 6 months, but I do believe that it easily could have caused the date to shift as to whether or not this facility could complete their construction. And I also, it's been a number of years in a former life that I have been in a transfer station to see the limited amount of space typically in a transfer station. So I'm just walking through all of it. I don't believe that all of the information has been put together in a way that I would like it to be put together. But I think if I take a moment and as we discuss this, that I might be able to pull the things together myself that I think might be able to make an argument for force majeure.
Senator?
The clause which says that they may anticipate an extension request, I'm of the opinion that that clause was put in by the respondents. And it's a game, it's my opinion.
Order. It's a stipulated order.
I understand that we, the other side, signed into a lot of things to get a stipulated order, but I'm just saying, it's my opinion. You can dispute my opinion if you choose, that was put in by the respondent, and it's something they can hang their hat on. Now, I would say to you that the planners of this construction project facility were aware, one, that they had some design changes. Those changes they made were mistakes or not clear, which necessitated the district making 15 changes. The district didn't make those changes on their own. They were necessitated by the fact that the respondent didn't give them accurate information in some cases, and that was testified to. The parking area for the Greenway, I asked you if you had requested a variance. You should know how to request a variance. If that was the problem where you needed additional parking, and you could commence building the transfer station there early on, you didn't ask for a variance from Huntington Beach to do that. You should have asked for it if you thought it was needed. But, if you knew you had a section in the abatement order whereby this time may be extended, then of course you could fall back on that, which is you are doing. And so I'm saying to you that you are aware in the positions that you hold, and And you testified to the fact that you couldn't do both construction concurrently at the same time. You can only accommodate one of those facilities being constructed at that site, with the trucks coming in and concrete being poured, so to be truthful. So it seems to me, based on arguments that I've heard, and the arguments well made by the district, I must tell you, they presented my point of view very well and what I think about this project based on evidence.
May I, I'm going to, Mr. Cameron, I'll call on you in a second, but if we could, I'm trying to understand, again, we have, what's being asked of this hearing board is to make a finding that delay was the result of a force majeure. And then, of course, force majeure, if it's due to permitting delays, has to be a demonstration by a respondent of diligence. The question is, can anyone point me, number one, towards what evidence we received, and walk me through how a delay of the permitting led to a delay in removing the green waste from the footprint of the secondary recycling building and where that construction was to begin, since we heard testimony that it could not commence until it got removed. I need to see what evidence we have that ties those two things together so that I could make a finding that the delay was a result of force majeure, if that's the force majeure we're going with. Can anyone do that? Because I think that's a very key and important element to our findings today. And if not, if there's any other comments that anyone wants to make. Mr.
I do.
Camarena.
Regarding the placement of the force majeure clause in the stipulated order, I don't find that to be unusual, given the agreement to provide the $250,000 for failure. I think in every situation, when you come to an agreement to do something by a certain time, you always have in the back of your mind, there are things that happen over which perhaps one does not have control. And that's the reason for the force majeure. Another point I'd like to make is that with respect to the permitting and the back and forth, both for the district and for the city and its various entities, they were looking at 410 enclosures for the first time. The district, on two previous occasions, had reviewed a 410 enclosure, but Ms. Shibata had not. And I believe that neither the city and its various permitting entities or the respondent and its contractor, no one had reviewed a 410 enclosure before, no one that was involved in this review. I asked Mr. Kentop about the parking. Somewhere, either in the testimony or the reading of documents, I recall that at one point in time, the employees, and I don't know how many, were in fact parking outside, and there were complaints by the citizens regarding the employees parking outside the facility and in the neighborhood, and that it was the city who asked respondent to get those cars back in their facility. it was the city who asked the respondent to get the employee cars back into the facility. I don't remember where I read that or heard that in testimony, but that is clearly my recollection.
I was going to say, my recollection was that I read in a declaration early on that it was the desire of respondent to be respectful of the community. But I don't recall, but I honestly don't believe that parking is the most relevant. With regard to the weather, with regard to the rain as force majeure, I just want to read the last sentence of that paragraph 26, which is force majeure does not include normal inclement weather. Now, I'm not saying that the excessive rainy season that was endured this last winter was normal, but rain is normal. So to count all 38 days as force majeure is not appropriate. I don't know what the appropriate amount is, but I'm pretty sure it's not 6 months. So again, I go back to the causation, and I'm yet to understand the tie between the green waste being on that area and not allowing construction to move forward until just perhaps a month ago, versus the city of Huntington Beach and its delay, whether it was diligence or not, non-diligence on the part of respondent. Ms. Byrd.
I was just going to ask if you can give me a minute to go back through my notes and if I can try to address what you're saying.
We're off the record.
Oh, wait.
Can you go back on the record and pose your question again to make sure I got it right? And you can take whatever,
We're back on the record, and would it be okay to take the senator's comments?
yeah, if you just pose your question.
Okay, the question is, in reading paragraph 26 of the stipulated order, I read, in totality, the hearing board, the findings that we can be requested to make and that we can make. So in the event that a petition for modification of the requested order is filed that asks this hearing board to make a finding that delay was the result of a force majeure, the parties have agreed to the following definition. So I believe that we need to make that finding that delay was a result of the force majeure, and just finding force majeure because of diligence is not enough, because there's no reason for that finding.
Okay.
Senator?
I can't make that finding either. It didn't rain 40 days and 40 nights. It didn't even rain 30 days. And it didn't rain for 7 months for sure. So you have delay here for 7 months, and has not been explained or justified, in my view. And the 40 days, 40 nights is very significant. It didn't rain 30 days, so no, I don't want to hear that as an excuse. Thank you.
Just to be clear, the testimony and evidence was not that it rained for 38 days, but that the day, I believe it's that the day of the rain and the day after, or perhaps 1 or 2 days after the rain, that would lead to delays in the type of work foundational work that was being done. That's why the 38 days was come to as the number delaying from rain. Anyone else have anything to say, or should we go back off the record and allow Ms. Byrd some additional time? Do you need more time?
The record for me, I'm not done. Anybody has anything to say?
Senator?
We build freeways all the time. It's raining, we improve Harbor Freeway. All this construction was going on. And they could do it. Concrete had to be poured. I just don't see the rationale for using this, making this finding.
I haven't found it, but I just did want to point out one thing as I'm reading through it again and again, that the demonstration is to obtain a permit necessary for construction or occupation. And that's where I was going back to, because I believe that there was some mention of occupation, and I'm just going through my notes to try to find it.
Let's go off the record for a few more minutes. We're back on the record. I don't know, Ms. Bird, if you wanted to begin, I had some things more to add to the conversation, but I'll wait if you had more to add.
Well, I'm still going back to the due diligence, best efforts to obtain permits. And I guess part of the issue is that I don't know if there's one thing that just pops out as the thing that shows due diligence and best efforts exercised as it results in the delay. But I think one of the things that stuck out, and this is if you feel or don't feel, I think I feel, that the settlement had any part in this. And I went back to the fact that improvements had to be done in sequence, because basically they had to be done in sequence because we requested they be done with a certain prioritization. And then the settlement agreement came along in November 2016, where that third building, the one that's not built, was agreed to be Rule 410 compliant, and that was based on the settlement agreement. That was November 2016, so that in itself changed the need for certain elements of permitting just based on the settlement agreement, and I'm still trying to decide if that's something that I want to hang my hat on. But that required extra filtration above and beyond, or they're providing extra filtration above and beyond some of the requirements of the district, which would have meant they would be changing their permit applications, and that was not anticipated. And that meant they had to change some of their City of Huntington Beach permits as well, and that definitely would not have been anticipated. And then back to the water issue, the rain. The testimony that I found was the stormwater lot had to be done in dry, not rainy season, but they were doing some of this work because it had to be done, and that the rain did delay it. So there were changes in design, the result of litigation that affected their permit applications. Now, if you want to say they should have known that they would have changes in their design based on litigation, that's an argument, I guess. But I think that might be one part of the whole process, as well as once that changed, those two things, once that changed and the fact that they could not do some of the work in the rain, I could see that there could be a delay based on that. And and I would say, well, I guess it says due diligence and best efforts. So I would say that for me, between the things that I just mentioned and probably a few other little details, I think that this definition as it's written here can be the case can be made, but that's my feeling.
I'm not sure I agree, and the reason why I don't agree is because I don't want to invent or surmise that it could be because this was changed, that I have to go with what was presented. And what was presented was that the reason why they're asking for force majeure based on a delay by permitting authorities was with the City of Huntington Beach and the fact that this stormwater infrastructure, which they knew had to be done, there's not a question that they knew had to be done. What they did not know was that it was going to be required to be done simultaneously and before occupancy could be granted on any of the three structures. It wasn't until the hearing, I went back over the declarations, I went back over the request for modification and the legal brief that supports it. I saw no discussion of the fact that the green waste processing was situated on the footprint for this building, for the secondary recycling facility. And what we did hear from Mr. Thompson was that was there from either January or February of this year through almost present. And it wasn't until that was moved that construction could really begin. We also heard some other things about having to park cars. Now, that was presented as a direct result of the permit being delayed and the fact that they had to break ground on the stormwater and then move the parking lot. But we also heard that, no, until the green waste was moved, full construction really could not commence. Perhaps they could move it around, shuffle it around, but we didn't hear hard evidence on that. So that is the real reason, and that, as far as the evidence is concerned, and not any delay in permit, and not, maybe there was some delay by rain, but I don't see 6 months. And I do also see that we received, again, exhibits AAA and BBB today to demonstrate to us that a district permit and that a public review and public comment period had to expire very recently, had to occur very recent as June, July of this year, before that green waste operations could be moved from that site. And that is the reason. So because of that, because of all that evidence, I cannot find, and due diligence aside, I cannot find that the delay for which the extension is being requested was the result of a force majeure being either the rain, because I don't see 6 months, or the permitting delay on the part of, due to the infrastructure addition of, and it's not an addition, the change in timing of when that stormwater infrastructure had to be put in. And again, I'm just talking about force majeure. I'm not saying whether or not I can find good cause for an extension, because I do believe I can separately. It's the force majeure. That's my thought. Senator.
Mr. Byrd just presented an argument about filters and some action that was taken last year. Responded, I thought you said something like, I thought I heard you say filters in the building. Then will you restate what you just said regarding the action that was taken last year? So I can respond appropriately.
Okay, I'm not sure which thing
When
you were talking about. I mentioned a number of things.
Justification for.
No, I just said that the settlement agreement was not something that was anticipated, and it required that they make that third building, that secondary recycling building, Rule 410 compliant, and that wasn't known until November 2016. I think that's what you're talking about.
Oh, yeah, okay. Right. Now, on that point, it's interesting that the respondents didn't make that as a claim for reason for justification.
Well, that was testimony that was presented last week.
I don't recall them making that as an argument for the delay, 7 months delay
Okay.
at all. But
Oh, wait, Ms. Bird, are you saying that you believe that the Rule 410 permit is a district permit? Do you believe that
Right.
they're requesting that we make the, okay.
I believe that as a result of the settlement agreement, when this first started, I mean, I guess sometimes it's difficult when we issue an order and we're still dealing with it years later. Because when it first started, they didn't have that settlement with the city, not the city, with the school district. The school district settlement required that they make that secondary building 410 compliant. That's what I have here. And that in itself would have required some changes to permit applications, because that's not what they had initially known that they would have to do. And I was just saying that if they didn't know that until November 2016, when they had started this process earlier, that in itself could have caused some delays in permit applications. But as you said, I can definitely, I think I have no problem with good cause. The question is the force majeure, as you said. But now, they are requesting a certain amount of time, and I do believe even if all the other stuff is kind of all over the place, I do believe that for the rain that we had, that they had some delay, and that would be under force majeure. Whether or not that's 7 months' worth is another question, but I do believe that in itself would have caused some delay in this project moving forward.
Sure.
Senator.
Is that settlement agreement with the school district available to us? I didn't know that it was.
Just through testimony.
Yeah, well, testimony is testimony. So the fact of the matter is that somebody testified that they're going to give them $4 million. When this, every effort has been exhausted before this body, or do they have it? I don't know. You know,
Well, testimony is evidence as much as any written
I
document is
know, but
evidence.
sometimes,
So
you know how that is.
no, I believe that I have to take, when somebody takes the oath and gives me testimony, I believe I have to accept that as testimony.
That's why you have appeals court and they overturn based on the testimony.
We do accept testimony under oath. However, we weigh it individually as to its credibility and
Thank God
weight.
we weigh it.
Unless there's any more pressing discussion on force majeure, I'm going to bifurcate the motion making and then the discussion. We can discuss the separate issues should we need to, but I'd like to offer a motion, and the motion I would like to make is that in the matter of South Coast Air Quality Management District versus Rainbow Transfer Recycling, Inc., case number 4394-2, with regard to the request by respondent for this board to make the finding that is anticipated in paragraph 26 of the findings under the stipulated order for abatement with regard to delay was the result of a force majeure, I move that we do not make that finding based on a lack of evidence presented that in fact the delay was the result of a force majeure, whether it is a rain delay from excessive rain or the permitting from the city of Huntington Beach, based on the fact that the evidence shows that in fact it was the inability to move the green waste processing that was taking place on that area of the property. And the senator has seconded the motion. Any discussion on that motion? Seeing none. Mr. Camarena, how do you vote?
Not ready to vote.
Would you like to take some time?
I
Did you have
just wanted to
discussion?
make a comment. First of all, with respect to the rain, I do believe that that contributed to the delay. I don't know to what extent. I don't know that it was all 38 days. I don't know if that was in addition to any delay that a contractor would build into its estimate of completion. All the contractors know that it's going to rain. All the contractors know that on the average, we have a certain number of days of rain. Was this 38 days in addition to that? That might have been built into the estimate. Don't know. But I do believe that that unusual rain did contribute to a delay. Mr. Thompson's declaration goes into a lot of detail as to what happened with respect to the requirement of the city regarding the water, and this was a requirement that they did not anticipate being required as part of the project. They believed that this would be something that would be required after. if you read through his declaration, you cannot find enough information that would add up to the 6 months. And I don't know that they could do that. There were so many things going on, so many entities involved, questions asked, iterations. And so I'm left with this, that is, it's almost impossible to fully demonstrate the 6 months requested. But I do believe that the amount requested is reasonable. That doesn't go to the force majeure, does it?
No, I think we're mixing.
Madam Chair,
Yes, Senator, and then I had something to add.
appreciate the comments from Mr. Camerino, but we're in the middle of a roll call. We're in the middle of a roll call.
Well, we could have discussion on the motion, so Mr. Camerino
I
was
thought
saying that he
you
did
called for a
not.
vote. We voted, didn't we?
I was about to call for the vote, but I had previously asked for discussion, so Mr.
Okay.
Camerino was adding discussion. And with regard to that, I could find excessive rain as force majeure. I can also find, putting aside the question of diligence, which I don't think we fully answered, I might be able to find, depending upon how we would go with diligence, that the permitting wasn't going forward, but that the foundational permit was granted at the rainy season time, which would further lead to the force majeure and any delay due to excessive rain. However, I still go back to Exhibits AAA and BBB and the testimony about them. And this is about the district's permits. And we have heard on several occasions that the respondent is not saying that the district's permits were what caused their delay. It's the city of Huntington Beach. By this point, which is June, July, the foundation's already built. So that delay is already in the past. And now we've still got this green waste sitting here. And the green waste cannot be moved until that public comment period ends and the permits are issued. So again, it's the causation that leads me to my motion. So if there's no other discussion on the motion, Ms. Byrd.
I don't follow I don't agree with your entire motion, but I do agree that we cannot find force majeure. And I only say that because I believe that the green waste, while that was an issue, that I believe that it resulted from other things, that green waste was not moved. And so to just say it was the green waste, I guess is where I'm having a problem.
So I'm going to amend my motion, and then I'm going to call for a vote. And the motion is just merely based on the discussion, based on the evidence that was presented. This hearing board cannot make a finding that delay was a result of force majeure. And that is acceptable to the second. If there's no further, Ms.
I just
Byrd.
had one comment, and I don't know if this is something that can be dealt with, because I don't know the legality of it, but is it possible for this to be one of those items that while we vote no on everything else, that it's allowed for them to, at another point, to just address another amount of time specific for the rain delay? Or if we vote today, does this mean that it's off the table completely? Because if they're asking for 7 months.
This,
She
no, wait,
did
this, no, this,
If
it
they're
is fine
asking-
to have discussion. I did ask for discussion.
If they're asking for 7 months and we don't believe that the delay would lead to 7 months, then perhaps if the delay could be thought to have led to 1 month or 2 months, are we now, will that just totally disallow for anything from petitioner? in the
No,
for-
I don't believe so. I believe that as I think Ms. Manwaring, I can't recall if it was Ms. Manwaring or Mr. Bruin pointed out, it's not a one-time thing. So should the respondent feel that it has a better case to present and wants to petition for force majeure and present different evidence, I suppose it has the ability to do that. But is that the question?
Yes.
I suppose it has the ability to do
Okay.
that. I can't
just
say
wanted
that for
that to be
sure
clear.
legally right now, but I believe it would. Mr. Camarena?
I have a question about interpreting this paragraph 26 in the order. It says, in the event that a petition for modification of the requested order is filed that asks this hearing board to make a finding that delay was a result of, and then it goes on. Does that mean the delay requested or any delay?
Well, I think for it to be relevant and germane to this hearing board's decision today would have to be the delay that's being requested. I think,
Please. Let's call for the previous question and end this thing.
please, point of order. The question was raised. I suppose it could be left for interpretation that this board can make a finding that some delay was. Again, we need evidence of that. And if there's no further discussion, I'm going to call because of the time, and we do have another issue should this motion pass to discuss. Seeing none. Please repeat the motion. Okay. I'm going to try. I'm not going to go through all the formalities of the name of the case, but the motion essentially is that the hearing board cannot make a finding that delay was the result of a force majeure. The delay requested was a result of a force majeure. And there was a second as to that.
How many times after the second that?
No, I'm just repeating that there was a second as to that. And it's based on the discussion we've had of the evidence. Mr. Camarena, how do you vote?
I vote yes.
Ms. Byrd?
Yes.
Dr. Lerner?
Yes.
That motion passes 5-0. Given that a force majeure, or that the finding required in paragraph...
Chair?
Yes.
There's a new voting procedure that you implemented?
Yes, you're so correct. Thank you. Senator, how do you vote, even though you seconded?
1, 2, 3 times.
No, you seconded.
Aye.
Thank you, and I vote yes. But motion passes 5-0. Given that, that motion passing, the next discussion is whether there is good cause for the modification and extension. And I think as several members of this board have expressed, I think there is ample evidence that there is good cause. It's very unclear what caused what. It's very unclear why we're in the position we are in, or why the facility is. But what is clear is that a number of things occurred, not the least of which that the facility did listen to this board and prioritized the 2 other buildings to be built first, which necessitated the green waste to be moved to that section of the property. In addition, there were delays due to rain. I don't know to what extent that changed any of the planning on behalf of the facility, but certainly it had an impact. Also, for good cause, I believe that we can definitely take into account the fact that the odor nuisance is what the NOVs were issued for, and that those 2 enclosures, the transfer facility and the MRW, I can't recall at this time of day, but those 2 that have to do with those that are odorous, those processes that are odorous, will be done by the December 1st deadline. In addition, even though the C&D processing was not the source of the NOVs, it has been addressed through interim measures, several of them, a change in the way the processing is done, less dropping of the C&D material. The piles that were the problem were removed. And so the extension of time, it doesn't seem, will create any more nuisance or any more discomfort or issues to the residences of this community, and especially to the school. There were no notices of violation within the last 18 months. And the school district, 2 representatives of the school districts did not oppose the request for an extension. Based on all of that, I do believe that there is good cause to grant the extension and make sure that this gets built and everything continues as is. Anyone else? Ms. Byrd?
I just wanted to agree with what you just mentioned. I'm sorry, it is getting late. And I think it's significant that no odor NOVs have been issued in the last 18 months, and this order was put in place because the students there were being inundated with odors, and so it has at least had that effect. And for that reason, in addition to what you said, I think that we can find good cause.
Anyone else?
Go ahead, Doc.
Senator? Oh, Dr. Lerner?
I agree. I think that we should go ahead with this. The question I have is that nobody has brought up, and they've not justified why 7 months. Why not 4 months? Why not 5 months? Why not 6 months? And I think the sooner the better off everybody is, even though the NOVs have gone by now that the 2 major buildings have been virtually completed. I just don't know why we haven't even taken this matter up at this late time. But if anybody has any reason to say that 7 months is appropriate, I would like to hear why.
I believe it's 6. Are you set? It's 6 months.
I'm
6
sorry,
months.
6 months.
It's based on the testimony of the respondent, based on Mr. Thompson's testimony, I believe, of what's the timing by which construction can feasibly be completed, I believe. Senator.
Well, they have a new general manager on site, and apparently he has a good working relationship with the community, and they work together to resolve this problem associated with this operation. And hopefully the expectation is that it'll be done in a timely fashion. I can understand why the people from the community did not object to this last building being built, because they want to complete the project, and hopefully after it's all done and completely operational, they won't have the problem anymore. Besides, $4 million does help them to keep quiet about their arguments. Perhaps, I don't know. I know the arguments before, and I understand some of the arguments now, but they're extending themselves to say, we want to work with the community. We want to solve the problem at the school, and we're willing to provide $4 million for the campus. You really can't argue with that, in my view. And they've shown a rationale, or a good reason for giving the extension that's requested. And I will support that. I see no objection to it. It's got to be done. And if they say 7 months is what they need, but the doctor's already mentioned, why not 4, why not 5? So he says 7 months or sooner.
6 months, actually.
6 months,
That was incorrect.
if 6 months or sooner is fine. So it appears they're working well with the community, and that pleases me a lot.
And also, just for the record, we also know that construction has not commenced, or maybe it has at this point, but as of the last hearing, the green waste had just been removed from the site 2 to 3 weeks earlier. So 6 months seems a reasonable time frame moving forward. Any other discussion, board members?
Do we have a
No motion yet. I will make one if there's no other discussion. In the matter of South Coast Air Quality Management District versus Rainbow Transfer Recycling, Inc., case number 4394-2, I move that we grant the respondent's request for a modification of the stipulated order for abatement and an extension of the final compliance date with respect to the secondary recycling facility to extend the date by which that construction and operation needs to be completed, or the construction needs to be completed and operation begin, to May 31st, 2018. There's a second by the senator. Any discussion on the motion? And that's based on good cause as discussed. Seeing no discussion, Mr. Camarena, how do you vote?
yes?
Ms. Byrd, how do you vote?
Yes.
Dr. Lerner, how do you vote?
Yes.
Senator, how do you vote?
Yes.
I vote yes. The motion passes 5-0. And it will, given that we are not making the finding of force majeure, we will simply amend. As the maker of the motion, I will make findings that are consistent with today's ruling. However, the date in paragraph, paragraph 1 of the order, condition number 1 of the order, will be amended to reflect the fact that for the final building, the date will now be May 31st, 2018, and that is on page 10 of the stipulated order. Anything further? Mr. Camarena?
I wanted to make one final comment about what we've done here today. This was not a violation of any district emission regulation. There has not been any further odor violations. This was about respondents' failure to comply with a provision in the order, which provision requires a respondent to build an enclosure that is not required by district regulations, but which was negotiated, and respondent failed to demonstrate to the satisfaction of this board the force majeure, but to me certainly demonstrated the need for an extension of time.
For good cause to extend that. And I think it's important at this point to commend the facility for all of the efforts that have been made to both comply with the stipulated order, but also, more importantly, to make amends with the community and to have such good open communication with the school district and the community. So,
Thank you, Ms. Camarena. If that opening statement had been made an hour ago, we'd be out of here.
I'll keep that in mind.
if there's nothing further, we are adjourned for the day. Thank you all.